Dear students, Assalamu alaikum to all of you. The topic for today is powers and functions of High Court. In the previous lecture, we discussed organization of High Court, then composition of High Court and qualification for becoming a member of Judge of the High Court. Then terms of service, tenure and oath, etc. Today our topic is powers and functions of High Court, and this topic is for students of political science of class 11th. So the topic is powers and functions of High Court. The powers and functions of High Court can be grouped into different headings. For example, we have number one, original jurisdiction. The original jurisdiction of High Court extends to all civil cases which are in matter of actions of higher value. Number two, appellate jurisdiction. The appellate jurisdiction of High Court extends to both civil and criminal cases. It comes as first or second appeals from several cases. Appeal from several cases come when a decision comes from the district judge or any subordinate judge when involves higher value case to the High Court. Similarly, decisions come on matters of law and fact when decisions come from the appeal of a district court or any subordinate court on an appeal from inferior court, then the second appeal lies in the High Court. The criminal appellate jurisdiction of High Court extends all those cases where decisions come from district judge or additional session judge and where the sentence of punishment exceeds 7 years. Now, point number third, power of superintendence. The High Court of a state has the power of superintendence over all courts and tribunals throughout the state, except those dealing with the armed forces operating within its territorial jurisdiction. Number four, control over subordinate courts. The High Court is the highest judicial system in a state, and it can transfer all constitutional cases from lower court to the High Court. If a High Court thinks that this matter involves a substantial question of law, then it may withdraw the case and dispose it itself. Similarly, guardian of the fundamental rights. According to Article 226, High Court is the guardian of fundamental rights within its concerned state, and it is empowered to issue a writ to any person or authority within the government if it feels that the fundamental rights of a person has been infringed or taken away. It can issue writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of fundamental rights. Lastly, court of record. The High Court is a court of record. Its decisions are also printed, and they also act as precedents for other cases in future. Thanks. This is enough for today. Khuda Hafiz. Stay home. Stay safe.